All right, let's roll, nerds. You are on bond for DWI, and now you've picked up another DWI.
Another DWI while already out on bond for the same thing? That's not just careless. It's a direct challenge to the court. And believe it or not, this case is just getting started. Buckle up.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On October 23rd, 2024, the officer was dispatched to a major one-car vehicle accident in Harris County, Texas. The officer made contact with a witness who observed the motor vehicle had left the scene but was still blocking a moving lane of traffic and had struck a school zone signpost. The officer also observed the defendant's motor vehicle had crashed in the direction moving against the flow of traffic, and the witness identified the defendant as the driver. EMS saw the defendant in the driver's seat of the crashed vehicle with her feet sticking out and the engine still running. Upon contact with the defendant, the officer observed bloodshot eyes, slurred speech, and unsteady balance on the defendant's person, along with a strong odor of an alcoholic beverage, and general disorientation and slow responses. When asked about the accident, the defendant stated she may have fallen asleep but did not remember the crash occurring. The defendant admitted to drinking and consuming Adderall, and she said that she was the sole occupant and operator of the motor vehicle.
Let's break it down. Open. Containers, Adderall, driving the wrong way, and failing every sobriety test. This isn't just a rough night, it's a textbook DUI case. And that 0.286 blood alcohol level? That's more than triple the legal limit. At that point, it's not just illegal, it's a serious public safety risk.
Beverage containers from the passenger side floorboard.
Drinking while driving?
Yes, Your Honor. And 4 unopened containers. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 8 out of 8, and one leg stand 3 out of 4. A blood warrant was drafted and executed.
And Judge, on the first DWI, the lab results came back as 0.286.
0.026.
0.206, because there's a big difference. Is it 0.26?
Yes, 0.286. Yes, Judge. Yes.
Yes, Your Honor.
That is a very high blood test. Can you run an NCIC? I'd like to know what other kind of criminal history she has, number one. Number two, did we have her sign a no driving affidavit on the first one? Because if she did, I'm going to have a contempt hearing.
I don't see a no driving affidavit on the file, Your Honor.
Yeah, well, her driver's license wasn't eligible though on the second DWI.
Probably because of the first and the ALR. Ms. Treadwell, I want you to be perfectly clear about something. I'm going to do everything in my power to protect the citizens of Harris County. Every single day, someone dies because of a DWI in Harris County. And I will do everything in my power to protect my city. And if that means putting you in custody because you repeatedly flaunt our bond conditions, so be it. Now, I'm going to revoke your bond and I'm taking you in. And now, if you do get out, you will have a strict curfew of 7 p.m. to 7 a.m. And I'm forbidding you from going within a car at all. You will now be signing an affidavit, and if I find that you drive, and I don't care what your reason is, I don't care if Jesus comes down and tells you he needs to ride to church, you get into a car and drive, I will have a contempt hearing. Every time you get into a car, it's up to 6 months in jail.
Let's be honest, this judge means business. She's now facing a GPS monitor, an alcohol sensor, a strict curfew, a higher bond, and a direct order to stay away from any vehicle. If she even thinks about driving, it's straight to contempt of court. So here's the question. If you were in her position, what would you do? Or better yet, what should the justice system do when someone keeps testing the limits like this?
A $500 fine. On one ankle, you will get a GPS monitor. On your other ankle, you're going to get a SCRAM device, so I know that you're not consuming alcohol. As it stands now, I'm revoking your bonds and I'm putting them both at $25,000. Do you understand? She goes with you. You now have picked up a new case. Mr. Arispe. You now stand charged with terroristic threat or a family or a household member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officer was dispatched to a residence in response to a family disturbance. The complainant, the defendant's stepmother, stated that the defendant was upset because he was owed money. The defendant told other members of the complainant's family, if they don't have my money by tonight, I'm going to kill them, as well as I'm going to send my people to shoot them up. The defendant also told the complainant directly, if you don't have my money by tonight, you are going to see. A family member of the defendant and complainant stated that he had seen the defendant walking around with a pistol in his pocket, and the complainant knows that the defendant owned several rifles as well.
This is where things take a serious turn. Threatening to harm your own family over money isn't just disturbing, it's a criminal offense. In legal terms, that's a terroristic threat, and since he was already out on bond for a weapons charge, this puts him on the fast track back to jail.
You were on bond for unlawful carrying of a weapon. Did we order him not to have one?
Yes, Judge.
Regardless, you picked up a new case. What happens now is I'm going to revoke your bond in the first place and you will stay with me. I will appoint you a lawyer today, Mr. Arispe, so we can talk about how to go forward, but I am ordering you now not to have any contact with these people. Do you understand?
Sir.
And I'm going to tell you, you pick up a third case, I'm going to go bonkers on the bonds. Do you understand?
Sir.
I'm going to do everything in my power to protect this public at all cost. All right, goes with you. Do you mind appointing him? No? How are you? You know. Who do you want to talk about first?
Let's do the strap.
Okay. Come up, Mr. Lestrap.
So Judge, there was misunderstanding on the case. So on his older cases, his appearance was waived. He wasn't required to come to court. It's when they did the new 2B on the new case, which I believe is beer and a bag of candy. And so that's when I tried to contact him to get him to come in. Couldn't get in contact with him. Then he had to schedule a court date for the old cases, and that's when the court revoked his bond based on those old cases. He said he received the letter, so he came in today to address the letter, obviously, and that's why he's here today.
So let's do probable cause on your newest case, because I don't know anything about it. Mr. Lestrap, you've now picked up a third theft case. You're now stand charged with another Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. The officer was dispatched to a Walgreens in Harris County, Texas, and the complainant, the manager of the Walgreens, told officers that the defendant entered the store and proceeded to take several items, including a case of beer and a large pack of candy, and walked past all points of sale without paying. The complainant told the officers that most of the employees knew the defendant by name and sight.
Where is the trespass and the theft, the prior trespass and the prior theft? Can you tell me where those are?
They are also at a Walgreens. Let me see if it's the same location. It's the same location.
I told you when you first came here not to go back to the Walgreens. Not once, but twice. What should I do now, Mr. Lestrap? What should I do? You tell me.
Judge, just for the court's knowledge, my client is homeless. He doesn't have a place to stay, no employment, has some assistance from his mom, but obviously that's not a whole lot. That's the number.
That mom over there?
I'm not sure.
No, it's not. She at home.
Did you come with mom today?
Yes, sir. She at home.
I don't know what to tell you, but here in court, we have resources, right? If you want resources, we're happy to give it to you. We had a kid in here yesterday, giving him resources to get a phone and a tablet. If you want a place to stay, we can find you a place to stay. If you want something to eat, we can get you something to eat.
You can hear the judge's frustration loud and clear. Yes, the defendant is homeless and facing tough times, but how many chances can someone get when they keep walking into the same Walgreens and helping themselves to beer and candy like it's free? At some point, sympathy and accountability are on a collision course.
But how on earth can I continue to let you go when, number one, you don't come to court? Number two, you continue to go to the place we tell you not to go. Number three, you continue to pick up cases when we tell you not to over a damn case of beer and a large pack of candy. Mr. Lestrade, they know you at that Walgreens. Every single time you go back to that Walgreens, you have about every single eye in the sky looking at you every 15 ways from Sunday, watching your every move.
Yes, sir.
Ray, I'm sorry. I'm not going to give another PR bump. You know, perhaps, I don't know, but you're not getting it.
Can we at least address the bond though, Judge? Because I believe the bond's at
Absolutely happy to. I agree that they're high. And what do you think?
Judge, I'd be asking for 500 on each case.
Okay, done. But the revolving door closes today.
Yes, sir.
It goes with you. I'm with you though. 500.
Appreciate it.
So this is Mr.
Yeah.
Worthy.
Mr. Worthy,
Yes, Your Honor.
you were placed on probation. You were on probation for unlawful carrying of a weapon. Now you've picked up a new case. So, we are now filing a motion to revoke your probation, and a warrant's gonna issue. We will take you into custody now.
If we would ask if we could set this for a hearing on the MAJ before we take him in custody.
Yeah, I mean, he picked up a new case. He's on probation. What we do is when you pick up a new case, motion to revoke gets filed. That's the normal course of business. You're supposed to not pick up a new case, right? Okay, goes with you. Okay, so why are we here on Mr. Jenkins? What happened?
Yes, there was, he was on bond and there's a new offense, so we're here for an arraignment. And then,
So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
that's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas driver?
Yes, Judge, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to address that.
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the lawyer.
Talk about my two cases before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today.
Anybody?
I'll give you a lawyer, another. If you want to get off, and I'll provide you another lawyer. It's the third case, unacceptable. Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes. On January 18th, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60 mile per hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are two very different things with two very different distinct smells. Additionally, if the officer is pulling him out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search, because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to
and
marijuana.
that, yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable.
Let's talk about search and seizure. The defense brings up a fair question. Does the smell of marijuana and a quick puff really justify digging through a sealed bag? It's a thin line between probable cause and going too far. What do you think? Did the officer cross the line, or was it the right call? Let us know in the comments.
Standard, which is the low stand, so
I understand.
I'm going to find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. It goes with you. Sorry, Sean, but he promised us he's not going to drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. The first case, I'm going to do it at 5,001.
Okay. So first case 5,001, and then the new case, of course,
I'll
would be
leave
bonded
the
out
first
as.
one or the second one as is, though. Now stand charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are in a dating relationship, and on January 25th, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated that he and the defendant are dating and that they had recently gotten into an argument earlier that day. The complainant stated that he had thrown some nicotine cartridges on the floor, and that the defendant and him got into a physical altercation but separated. The complainant then made food and brought the defendant a plate of food, but the defendant used it to strike the complainant in the face, causing a laceration above his eye. The complainant then stated that he began to fight back.
Same complaining witness in the terroristic threat?
No, sir, Your Honor, it's not.
No, Your Honor. It does appear that the complaining witness in the recent assault was a witness to the previous terroristic threat, but I'm still not sure the involvement so far.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
Yes, sir.
I ask you one thing. I ask you not to pick up any new cases. You have done, because you have done this now, I'm going to revoke your bond on your first case, and I'm going to put you in jail right now. Goes with you, officer.
Thank you, Your Honor.
Thank you, Mr. D. 5001.